I'm Haze Hartwig. This is Bamboo, Vancouver's property management and investment podcast. Hello again, everyone, and welcome to the show. Today we are going to be talking with Phil Dougan from Citadel Law, mostly about what happens after you win at RTB. We've all heard the horror stories about different tenants and the battles that go on between landlord and tenant. This here will be able to help us sort of see what the options are after you win. So without further ado, welcome to the show, Phil.
Thank you very much.
Tell us how to go.
Yes, indeed. Well, it's an interesting conundrum for landlords. Is often it feels like a very Pyrrhic victory to win at the RTB, which we know is hard enough in the first place. But then, usually having received a monetary order, shall we say, for damages or what have you, then what does a landlord do? And the trouble has been that it's almost another lawsuit unto itself to collect it. And quite frankly, still to this day, the first question a landlord or a property manager should ask themselves is it worth the second step? Because it really is starting another legal process. So far and away, the most important question is cost benefit.
Yeah.
What time, what money, what energy are we going to put into this to collect $5,000, $10,000, whatever it may be? Now, obviously, the higher the value of the damages claim or the monetary order, the more, it is going to be worth it. Then there's also things, quite frankly, like deterrence. Is it worth the landlord's time to do this simply so that it doesn't happen again? Right?
Yeah, absolutely. So my grandma used to say, is the wear worth it on the chicken's ass?
So. There you go. Very aptly put. So those are the kind of parameters we're going to put around this, because there's a number of options open to us.
Yeah.
But none of them are straightforward and none of them are quick.
Yeah.
Right?
Fair enough.
We have to be prepared to either the property manager is going to put in the time, the landlord's going to put in the time, or even a lawyer put in the time, depending on the complexity and the matters involved.
Yeah, so it's more of a marathon than a sprint, is what you're saying.
Oh, yes. No, and understand, the court will help you because unlike when you start at the RTB, now you are the winner. Okay, so the terminology changes a little bit. So let's be clear about who we are. If you are a landlord that has successfully won a monetary order at the RTB, you are now what's called the judgment creditor. Okay. And then the tenant becomes the judgment debtor. Okay. So guilty as charged, as it were. That's the difference between these proceedings and going to the RTB in the first place, where it's on a balance of probabilities who's going to win.
Yeah. Absolutely.
But once we've won the order, so we've got an order for $10,000, let's say, we now have multiple choices of things to do through the provincial court ordinarily. So the small claims court is probably where we're going to go, unless we're dealing, which is unlikely, with anything over $35,000.
Yeah.
Up to $35,000, we're in the provincial court.
Okay. So just for our listeners to know here that we are making the assumption that you have already won your monetary order at the RTB. So don't come out of the gates trying to do these things without being the winner at the RTB.
That's right. Exactly right. So you should have an order in hand that says we award the landlord $10,000 or whatever it is.
Okay, perfect.
And so there's 4 or 5 different things that we can do at court to enforce the process. And what I'd like to do is actually mention garnishing first, not because it's necessarily the most effective method, but because the government has introduced new legislation that may assist us in the future. So not sure when this will happen. Could be this year, could be next year, could be the year after.
Yeah.
But basically, the idea is that the government is going to move into the area of assisting judgment creditors in collecting their money via garnishment. Okay, so let me explain what garnishment is first so that we're clear.
Yeah.
We've got a judgment creditor who is owed money, a judgment debtor who owes the creditor money.
Mm-hmm.
And in a garnishing situation, there is a garnishee who also owes the debtor money. Okay, so it's a triangle, if you will.
Mm-hmm.
He owes him and he owes you. What normally happens in that situation is the garnishee, the person who owes the debtor, is actually a bank.
Okay.
And they owe them in the sense that they are holding their money.
Yeah.
And if you go to the bank and say, I'd like my money back, please, they have to give it to you. And if they don't, well, then we've all seen, It's a Wonderful Life. There's a run on the bank and it's a big mess. Right? Yeah. So in any event, ordinarily the garnishee we're talking about is a bank, but it could also be an employer. It could be another individual. It could be a company. If the judgment debtor in our case is themselves trying to collect money from someone else.
Mm-hmm.
So anyway, we have this triangle, and rather than chasing after the judgment debtor all the time, the judgment creditor can simply serve a garnishing order on the garnishee, the bank, and say, you owe him, but he owes me, so pay that money into court, and then I'm going to go collect it. Okay. Now, the trouble with that has been in the past that and you know what it's like, most people are living paycheck to paycheck. So on a particular Friday, there's a few bucks in there, and then by the following Tuesday, there's hardly anything left.
Yeah.
So you always had to time your garnishing order to when the money was actually there. Mm-hmm. And of course, that's really difficult because you might not know when your tenant gets paid or even which bank they're in, which is a whole problem unto itself.
Yeah.
But there was always this process, of always having to time it for the paycheck. Mm-hmm. And the garnishing order was only good for that particular time period. Yeah. So whenever you've filed it at the bank, they would look at and say, okay, what's he got in his bank account? Can we assist? Exactly. But if he spends it all on Friday night and you get it served Saturday morning, you're out of luck, right? So apparently, the theory of, I'm going to make sure I read it right, it's the Money Judgment Enforcement Act, which is just at first reading. Okay. So it's got to go through 2 readings, and of course, the legislature is closed for the summer holidays. Yeah. But what the idea is that if you get to the point of having a judgment, the government will assist you with the garnishing order, and it will be basically a garnishing order once and only once until all the money is paid over.
So now that would be actually very helpful.
That's right. So this is a bit more, when I read that, I thought this is a bit more like, for those of your listeners who may know it, the Family Maintenance Enforcement Program, where if you owe spousal support or child support, they basically just come along and take it.
Yeah, fair enough, right?
Okay. So it sounds like it's a bit more like that, where the government will simply intervene on behalf of the landlord who's got an order, says they're owed money, and it will simply say to the bank, okay, every time he gets a paycheck, we want $200 going to the creditor, or something of that nature. Okay. So that's quite hopeful. Just to mention in terms of the process as well, because sometimes it can be an issue as to timing, as to when you even put in a garnishing order. Mm-hmm. There are pre-judgment garnishing orders and post-judgment garnishing orders. And there's a couple of other different things as well, but those are the main ones. Yeah. And obviously, as the name suggests, the pre-judgment one is before you've even proven your debt.
So you'd do that like ahead of the RTB case? Even.
Exactly. Okay. Exactly. And the reason for that is that sometimes people have money today, but as soon as you file a lawsuit, that money disappears off, and it's suddenly in Aunt Matilda's bank account in Alberta, and you have no idea how to get to it. Okay. So it's a self-help mechanism, if you will, so that you can avoid what the courts call a dry judgment. Mm-hmm. And this is the central issue of what we're talking about today, quite honestly, is how many landlords have won and then never got paid. Yeah. Right? And that's our problem here, is we've got lots of people winning judgments, or at least getting some sort of monetary order, and then being completely unable to collect anything from it, right? And then you're kind of wondering, well, why did I bother, right? Yeah. So we're trying to get to a place where the bother is actually worth it. And there is some incentive to say, okay, cost-benefit analysis, sure, let's do this. Right?
Yeah.
We could get some money and it will stop the next guy just thinking he can do whatever he likes and there'll be no ramifications.
Yeah, because that's a lot of our landlords have run into that feeling that they basically have no teeth, like the toothless dragon, which, I mean, as long as it's been proven properly, I mean, they should be able to go after that. So a lot of them just feel sort of like powerless almost.
And I mean, and you and I both know that many tenants simply are, you can't get blood out of a stone. They just don't have very much.
Yeah, absolutely.
And that's a different issue. But some, are quite well paid and they're simply just avoiding their responsibilities. And just because they had a raucous party and caused $5,000 damage to the rental property and they just don't remember doing it, doesn't mean that they should not get paid or not have to pay for the damage. So these are the important things for this. So garnishment is okay just now if you know the details. Where is the bank? When do they get paid? How much money are they likely to have? Mm-hmm. You can kind of take advantage of that. And then definitely when the Money Judgment Enforcement Act comes along, it sounds like that's going to be a lot more of a viable option with far less hassle than there currently is.
Yeah.
So stay tuned on that one and we'll see what happens. But, hopeful that, because I think, to be fair, on the tenants, and we'll come to this in a moment when we talk about payment hearings, if you've got a $10,000 judgment, they're not going to write you a check for $10,000 because they don't have it.
Yeah,
right?
And that's fair enough.
But $500 a paycheck, $500 a month, $1,000 a month, something of like that, is more reasonable. Mm-hmm. So, landlords should also come into this process with a little bit of an expectation management as well, right? Yes. We're not coming into this to win gajillions of dollars and throw the book at them and have legal fees and all that kind of stuff. It's not going to happen in this process.
Yeah.
There is no legal fees in the small claims court. Okay. So if you do have to retain a lawyer, that's your cost. So if it gets back. Yes, you can't get it back. You can get a portion sometimes, but assume zero, and then that will help you with your cost-benefit analysis. Because sometimes it is worth it just for the deterrent, or even if it's just to get $2,000 out of 10. Sometimes it is, and you've got to kind of come to that place.
Yeah, absolutely.
Perhaps even in discussion with the lawyer, because the lawyers, quite honestly, will be ones who will be saying to you, it's not worth it. It's not worth it.
Yeah, exactly. Pick your fights, right?
Yeah, because they know how big their own bills are, right?
Yeah, absolutely.
But sometimes, there is definitely a moment when it can be worthwhile. Mm-hmm. Anyway, let's talk about the payment hearing process in the small claims court, because I think it's the most practical at the moment, and it's the most effective system that we have to get tenants to take a debt seriously and to actually do something to resolve the debt, even if it is ultimately only a portion.
Yeah.
So let me explain what happens at a payment hearing. Once you've got your order from the RTB, you have to register it in the small claims court, which is a little bit of a palaver all by itself, but you register it in the court. And what that does is it turns the RTB order into a court order. Okay. So now it's more important in terms of the pecking order in law. Once it's a court order, then there are things like the Court Order Enforcement Act, for example, and the court rules that now begin to apply to that judgment, because obviously the courts have a very strong vested interest in their orders being obeyed. Of course. This is the rule of law. If court orders are meaningless, then we're doomed, right? Because next stop is whoever's got the biggest baseball bat makes the rules kind of thing. And we don't want to go there.
No.
So a payment hearing is wonderful because I think it brings home to a judgment debtor the seriousness of the situation. So you file your judgment in court, and then you basically prepare and serve a subpoena on the debtor, which says, please come to court next Thursday for a payment hearing. Mm-hmm. But what it also says is, please bring your pay stubs, please bring your tax returns, please bring your bank account, or whatever else you may think will prove their income, their incomings and outgoings, so that we can have a good picture of what they're earning and what they're spending.
Right? Yeah. Now with that as well, like some people are in multiple banks, so do they have to bring all of them? Just one? What happens if they don't bring them?
Right. Yes, they are required to bring all. Mm-hmm. And what I find is, if at the first payment hearing they don't bring anything, the justice of the peace who do these hearings are completely used to that. People never want to bring anything. And so if it becomes important, if we can't get to the bottom of the arguments about money, then they will be ordered to bring those documents. And if they don't, they may find themselves arrested. Okay.
Would definitely get the attention of somebody.
Get somebody's attention. Exactly right. But the idea is not that we get into the minutiae of their tax returns, because probably as landlords, we have an idea of their finances, right? Otherwise, they wouldn't have been tenants.
Yeah, fair enough. Yeah.
So we've got a starting point at least. And we're not, as I say, we're not using this as a way to infiltrate their lives and find out every detail. We're just trying to get paid, okay? Yeah. So they have to come with some explanation of their earnings and outgoings. And then what the justices of the peace will do is basically say to them, well, how are you going to pay your debt?
Yeah.
And they'll say, oh, well, I don't think I should pay it. And the judge will say, I'm sorry, that we're past that now. The courts have said you have to pay this. How are you going to pay it is the only question I want answered. And it always seems to go that way, funnily enough. But anyway, then what will happen is hopefully that person will get serious and they'll realize they can't just say $50 a month for the next 25 years.
Yeah.
And they can't, obviously, most of them just write the check right there and there. So somewhere in between. And usually what the justice is looking for is between 6 and 12 months of payments so that the thing is done.
Yeah.
And even if that is 6 to 12 months and we get to 80 or 90%, and the landlord says, you know what, that's good enough. I'm fine. I just don't want to deal with this guy anymore, but I would like to get the bulk of my money back. Okay.
Yeah, which I was actually just going to ask you that. Like, can a landlord say, I got my doors fixed or whatever, we're good to go again, that sort of thing? Because I think a lot of them really just want that dealt with afterwards. They just need the place back to being able to get rented again so they can get up on their way. They don't care overly. They're not trying to get that guy. They're trying to just get the back so they can get out there again.
Well, and that's a very good point, right? Is that, again, in cost-benefit analysis, we're not going to sit around and wait for the tenant to pay the bill before we repair the unit and re-rent it, because if we've got it re-rented, we're already beginning to recoup those funds, right? Yeah. So, yes, that's, again, kind of that perspective and having your sort of expectations in place. And most landlords, I find, they're business people first, and they realize, that you can't get too emotional about these sort of things.
Yeah.
But it is very frustrating if you just spend $25,000 on a unit, and some schmuck comes in and wrecks the whole thing, and you've got to start all over again, right?
Yeah.
I get it.
Yeah, absolutely, right?
And so the nice thing about the payment hearing, too, is, as I say, it sort of brings home the significance of this, because sometimes debtors don't realize that this is important. So they get the subpoena and they just don't show up. And it's my favorite moment in all of my legal career is the justice looks at you and says, well, Mr. Dougan, what would you like me to do now? And you get to say, issue an arrest warrant. And that's exactly what happens. It's called a non-custodial arrest warrant. But it basically is a sheriff goes to the debtor's house and serves them that. And it will say, okay, you didn't come on Thursday, so you better come on Tuesday, because if you're not there, I'm coming back and I'll be back with the dangly handcuffs that I carry around, and you'll be coming with me whether you want to or not. So, again, it sort of is the sharp end of the law there, that they could literally end up in the cells in the courthouse for a night. And so, again, it brings home the significance of this. And then, again, it's really an enforced mediation about the payment, not a mediation about should you win or lose, but simply about the payment. And that, in my experience, is the most effective because it gives tenants who are probably pretty cavalier, they've got away with it, or they've never thought there was any consequences. All of a sudden, they're in public court, and there's 25 other people there fighting their speeding tickets or whatever else they're there for, listening to this story. And it's amazing how powerful peer pressure can be.
People are now looking at like, what the hell?
Just pay your bill, buddy, for goodness sake. And so that one, sort of as a practical measure, is often the best one to look at, or at least the first one to look at. Because also the timing of it is not months and months; it's days and weeks.
Get the show over.
Exactly. And then if you get that order where it says, okay, the debtor will pay X dollars per month on the 1st of the month, on the 15th of the month, or whatever it's going to say, then that starts. And you usually, part of that order, you have the sort of ultimate clause that, this is as for the convenience of the debtor, but should any payment be missed, the whole debt will become due and owing immediately. So then we are expecting a check, and we are expecting them to go get some financing or what have you. So it gives them incentive to stick to the plan.
Now what happens if they don't?
Then it starts getting very difficult because, unfortunately, the judge is now starting to run out of tools. They can arrest them for contempt, because that's essentially what that becomes. If you go into that step, contempt is quasi-criminal, so you also have to prove it beyond a reasonable doubt. It's kind of another hearing, if you will. And then the court really only has 2 or 3 remedies. It can put you in jail, it can fine you for the contempt, or in some cases, like an strata situation, they can order the sale of your unit, right? So that's obviously not one that applies to us particularly, although landlords need to be careful because it might apply to them.
Fair enough, right? These all go the other way too, right?
Exactly. They go both ways. So be careful with those. So that's a difficulty. And this again was where we're right back to the beginning about the cost-benefit analysis. If this is a guy you're dealing with who's semi-homeless, got a fairly serious cocaine habit, you've got to think about this really hard.
Absolutely.
But if it's an engineer who just had a stupid party and they're earning good money and got a bright career ahead of them, they're not going to want this blot on their copybook or even on their credit rating.
Absolutely.
So, that's again part of the analysis, I suppose, right at the beginning about should we do this is it someone who's going to be adept at, acquiescing to the court's order?
Absolutely.
Because at some point, people simply don't care anymore. They have nothing to lose.
Absolutely.
And those are not people that the court could easily deal with, as we've seen over the last how many decades where we've been trying to deal with mental illness and drug abuse with the criminal code. And of course, it doesn't work.
Absolutely.
These are completely different issues. And the same goes, just because there happens to be a debt coming along as well, that doesn't mean that the person who's homeless or drug abused or what have you is going to be in an any better situation just because we're talking about a bit of money.
Absolutely, right?
So those are our 2 primary methods for dealing with a monetary order which from the RTB into the small claims court. There's another one that I'll mention because sometimes it's helpful. This is the right of seizure and sale. Okay, so this is the circumstances, and again, you're going to have to analyze your own particular situation. Maybe there's the tenant who's got the very fancy motorbike or the boat or the ATV or whatever toy they've got that's their pride and joy, and it's actually worth something. All right. Now, we have to be careful. There's a thing called the PPSA, the Personal Property Security Act, which creates the PPS, whatever it is, the registry, PPSR, I guess you call it. So if there's a loan on the toy. You've taken out financing to buy the new car, which often is the case, of course. But sometimes bikes or ATVs or what have you, because they're less money, sometimes people either buy them outright or they pay them off relatively quickly, because you're talking $5,000 to $10,000 of borrowing versus $50,000 to $60,000 of debt. Anyway, so assuming though that there's no financing on it, which basically means the bank owns the bike or whatever, then we can get the sheriffs or the bailiffs to identify that bike and seize it and sell it. And whatever they get at auction for that property, once they've deducted their fees, goes to the judgment creditor.
Now, is there a way to find out if there's money owing on that, or is it just kind of take a shot and hope?
No. Yeah, no. A lawyer can look it up for you on the PPSA registry, just to see, because basically via I think it's the VIN number for a vehicle or what have you, they can check to see if someone has basically said, hey, we've put out a loan on this, so it's ours until the loan is paid off. So that's a pretty straightforward, kind of like checking title.
Yeah.
It's that kind of idea. So that's fairly easily done. And then if there's nothing on the PPSA, then as I say, the bailiffs can be involved. And so again, you've got to look at, is it worth it? Because the bailiffs could be...
Yeah, they're usually around like $3,000, so
can be.
Got to make sure there's a gap here, right?
I mean, and get them to explain how hard or simple this is going to be. And they'll quote their fees accordingly, because obviously they just charge for whatever hassle they have to go through to get the job done. But again, it can be useful, because again, there might be some actual real money at the end of it for a landlord. Plus, you've got the added insult to injury to the debtor, that now they've lost their pride and joy.
Yeah,
right? Exactly. And sometimes that can be very, very powerful. And I have had property managers tell me that even a debt going on to a credit rating can have the same effect. Like, people don't want to lose their pride and joy, even if it is their credit rating. Yeah. So, these are things to keep in mind. And we have to become quite shrewd in these circumstances. What is the best way, as you were saying earlier, just to get this dealt with, right? That's our goal. We really don't care the bigger picture about trying to get the tenant back on the straight and narrow. We just want the debt paid, the unit repaired, or whatever needs to happen, so the landlord can move on.
Yeah, absolutely.
And so sometimes, again, depending on the circumstances, seizure and sale can be a very useful tool, sort of a blackmail tool. It's lawful blackmail. One other that I will mention that can come up, and then the last one is just minor, but registration against land. Okay, so you've probably heard of people talking about putting a lien on property, these kind of ideas. You can do the same with a judgment, and that's literally what it's called on the title of a property, it's a judgment. So if they own property, like real property, anywhere in the world, that's gotten a deal with Canada, so certainly in the US, for example, like let's say they have a family cabin or something, right? It may not be worth huge sums of money, but it might be worth $100,000. And if you're looking at a $50,000 judgment or a $30,000 judgment, then that might be a very good way of getting paid. Because what happens is you put the judgment onto title, and just like a lien, it basically stops anybody dealing with that title, because they know if they buy the place, they have to pay the judgment. Yeah, basically. So they're not going to buy the place. So what it does is it kind of freezes that property, and then the judgment, you have to renew it every 2 years if you're just going to use it as kind of a manipulative tool to say you cannot sell this property, you can't transfer it to anybody else until you deal with me. You can do that up to 5 times, so 10 years. 10 years, okay. You could just kind of freeze the property if you want to. But of course, again, back to our point, we just want this settled and over and done with. Then once you've got judgment on title, then the Court Order Enforcement Act that I mentioned earlier becomes part of the process. And there is a 3-hearing process, and 2 of them are very short hearings, basically, where the courts authorize the registrar to look at the property and to look at the debt and basically ask very basic questions. Is this debtor the person who owns the property? Is the debt real? Is the property real?
Yeah.
Can we say we approve a sale?
Okay.
Once the registrar has done that, they do what's called the registrar's report, and then we go back to a judge and say, okay, judge, the registrar has confirmed that it's a real debt from a real debtor and they own this property. So now we would like the order for sale of the property. And then you're entitled to sell the property
to get your back.
And you pay yourself back out of the proceeds of sale. And usually what happens is there's certain costs that are incurred. There might be some back taxes. You might have to employ a realtor to deal with that. They have to be paid. Then the landlord gets paid, and then whatever's left gets paid into court.
Yeah.
Because it still does officially belong to the debtor. But then they can go and apply to court to get the rest of it out. So that's pretty rare, but it does happen.
Yeah, probably better used for like when we have guarantors, for instance.
That's right. That's right. Those kind of situations where you've got some leverage, because of course, some people, they'll be from out of province or out of town, and they'll think that you don't know or you can't find out if they have property. But it's not that hard, right? Not at all. And I mean, I have access to the land title office as a lawyer here in BC. I can phone a lawyer in Alberta and say, hey, can you check land title in Alberta and see if Joe Blow owns property there? So it's not that hard to begin that process.
Yeah, I mean, as far as that, when you're checking on properties in other provinces or even in our province, how do you go about making sure that Joe Blow is Joe Blow? Because, for instance, like the last name Smith, there's heaps of them. How do you make sure that you have the right one?
That's a very good point, yeah. So often the court records will use middle names as well.
Okay.
And then you're kind of switching over to things like estate law, where we need to be sure that Joe Blow is Joe Blow in the will, for example, right? And then we'll start looking at date of birth and locations. So, you fill in a form and you give your address today, and then 5 years from now you've moved 3 times. Well, that doesn't matter, because if you're Haze who lived here at this time, then the courts consider that proof that you are the Haze that we're now looking for later.
So yeah, as a tip to the landlords, that means when you're getting a guarantor, make sure to grab the middle name as well. A lot of people just sort of skip over that part and may be beneficial later in the future.
Oh, and that's a very good tip, Haze. In fact, I often say in any time you can, just in the informal dealings with a tenant, pick up as much information as you can, because, for example, we've all had it where the tenant, has caused damage and then disappears in the night, never to be seen again.
Yep.
But if you know that Mum's name is Agnes and she lives in Calgary, well, you can find Agnes and then you can substitutionally serve her delinquent son with your claim. And so you can still get approval from the RTB to serve things that way, even though you have no idea where the tenant actually is. So picking up little tidbits of information, you never know when it might assist the lawyer in figuring out, or even with those who go overseas, we have skip tracers, and they do amazing work. I mean, I had one once, found a 22-year-old in Bangkok.
Wow.
And Bangkok's like 20 million people, and it only took him 3 days to find her.
Wow.
So, if you give them enough information, they can find just about anybody. So it's always worth keeping in mind, and so details should go in the file that might just assist later on, as you say, to confirm ID, prove other locations for addresses for service or other family contacts. And then, of course, just practical things. If Joe is killed on his fancy motorbike, you might be the one trying to find next of kin or being involved in that process. because the police say, well, he didn't have his driver's license on it. Who is he? So anyway, lots of reasons to keep your file up to date with anything you learn. And as we've been saying, in these processes, trying to evaluate the situation carefully is key. So the more information you have, you guys have a rec property up in Kelowna. That's lovely.
Noted.
Could be, yes, exactly. Could be very useful another day.
Okay.
So that's most of what I want to say. The only other thing I was going to mention is default judgment, which is the idea that you win because the other side doesn't show up.
Okay.
So it doesn't happen very often, but it's certainly for the purposes of the RTB and then anything in court, it's worth keeping in mind. Just because they say we're not coming, or you've had to serve them substitutionally with mum in Alberta, but you have no idea whether they've actually read it or heard about it or know anything about it, that is irrelevant.
Okay.
Service is not whether they've read it or not. Service is whether it's actually been complete or not. And if the courts or the RTB says, no, that's okay, we understand Joe Blow is hiding from you, evading service, but his mum lives in Calgary, you can serve him by sending it to his mum by mail, and you can email it to him at the email where he always used to respond to you regarding, fixing the dishwasher or whatever. And then if they don't respond at all, you still go to the hearing and you say, well, then I would like default, because basically is I've proved my claim because there is no defense. There's no one here to defend the claim.
Yeah.
Now, the RTB adjudicators will not always just do that, but judges usually will, because they'll know the process and the ins and outs, and they'll know that if you don't actually put up a defense, then presumptively the plaintiff wins, as it were.
Okay.
So always assume that you're going to the hearing, regardless of what has gone on, because the adjudicator is just going to say, well, what did you do for service? And you can say, well, here's our alternative service order. Here's the proof that we mailed it to Calgary. Here's the email that I sent to him with the materials. So it's been properly served. We're seeking an order for $10,000. And since he's not here today, there is no defense to this. We say we have proved our claim, and therefore we would like an order for $10,000.
Okay.
And that's it, kind of thing.
Yeah,
so it's handy if that scenario ever arises. And occasionally it does. I had one just 2 or 3 months ago where one party didn't show up. And so we all agreed that the RTB adjudicator was completely free just to give the order.
Yeah.
Because what else was he going to do?
Yeah, so basically, Boy Scouts, come, be prepared.
That's right. Be prepared. That's exactly right. So there's lots more that can happen, but I think the takeaway is you've got a number of tools in your tool belt. Once you get to that point, decide whether you're going to even use those tools.
Yeah.
First, make that very clear to yourself. But then if you are, then pick the right tool, because they're diverse, as I've sort of intonated here, and then just get on with it. Because, the end goal is simply either a complete resolution or even, as we've been saying, a partial resolution. That's better than nothing.
Yeah.
And hopefully, too, it gives you as a landlord a bit of a reputation that you're not to be trifled with. And then hopefully, because you know what it's like, we just don't need these kind of hassles in our business, right?
Yeah.
Everything's great as long as everything runs smoothly. These kind of situations blow everything out of the water. So we're trying desperately to avoid them. So if a little bit of deterrence will avoid the next one, well, then so be it.
Absolutely. Well, thank you very much for stopping by and sort of enlightening us to some of the extra tools that can be out there. We'll have all your stuff in the description, of course, but if someone's trying to get a hold of you at Citadel Law there, what's the best ways to get some lawyer action if you need it?
Sure, absolutely. So our website is www.citadellawyers.ca. Otherwise, of course, our office is downtown, right by the courthouse, and are just for the record, our phone number is 778-945-9990. That's the main office line.
Excellent.
But as I say, we're on the internet, so
yeah, for sure. And, we'll have everything in the description below, so people can just to find it there. So,
thank you.
Awesome. Well, thank you very much for stopping by the show, Phil. If you guys have found anything interesting and or useful for this chaos or anything else, please feel free to like and follow us. They will be back in a couple of weeks with all the goings-ons in the rental market, as well as some stats. Thanks for listening.